In this installment of Washington Legal Foundation's Legally Brief, Kelly Savage Day, an attorney in the San Francisco office of the law firm Sedgwick, Dietert, Morin, and Arnold, joins us today to talk about how the federal courts are addressing preemption arguments in state tort suits targeting generic drug makers. Kelly, we know federal preemption of state tort law has quickly become one of the most significant, high-profile issues facing litigants today. The United States Supreme Court has decided a rash of preemption cases in the last few years, most recently in Wyeth versus Levine, and will further clarify its position on the preemptive effect of federal agency action in at least 2 additional cases this term. The Court has also asked the Solicitor General to weigh in on preemption in the generic drug arena in the Mensing versus Wyeth case. Now, you've successfully represented generic pharmaceutical companies in the product liability arena in both state and federal court in California, which is one of the least friendly jurisdictions for defendants in the country. As we sit here today, can you tell us where courts stand on preemption in the generic drug context? Are state law failure to warn claims against generic drug manufacturers preempted or not?
There's an ongoing debate. Courts have come down on both sides of the issue. The majority have concluded that the federal regulatory regime governing generic pharmaceuticals does not preempt state law failure to warn claims against generic drug manufacturers under the reasoning set forth in Wyeth versus Levine. Many commentators have read these decisions broadly and maintain that Levine forecloses future preemption arguments by generic manufacturers. That goes a bit too far. Under the plain language of the Federal Food, Drug, and Cosmetic Act, the label for a generic drug must be the same as that of its brand name equivalent. Generic manufacturers may not unilaterally change their labeling to add or strengthen warnings when there's been no change to the labeling of the brand name drug. Period. End of story. For those of us who represent generic manufacturers, we're hopeful, though not overly optimistic, that the Solicitor General will clarify this issue when he files his amicus brief in the Mensing case. But until we see that briefing, and until the Supreme Court definitively decides the issue, generic drug manufacturers should anticipate increased product liability litigation and continue to assert the defense. Although Levine has undoubtedly made it more difficult for generics to succeed on automatic preemption grounds in certain jurisdictions, these decisions do not make all preemption arguments impossible. For example, Levine does not preclude continued application of the defense in those cases where the FDA has specifically considered the particular risk at issue and has determined that the product's labeling adequately warns of those risks. Likewise, state law fraud on the FDA claims against generic drug manufacturers should remain preempted under the reasoning set forth in Buckman.
If the Supreme Court ultimately concludes that state tort law claims against generic drug makers are not automatically preempted, then what does this mean for the generic pharmaceutical industry as a whole? And what adjustments should affected companies be making now and in the future to respond to the potential for increased litigation and/or government investigations?
If the Supreme Court ultimately concludes that the automatic preemption defense is not available, this will have far-reaching consequences for generic drug companies' workforce, investors, and most importantly, consumers who rely on generic drugs to meet their medical needs. Such a decision will result in more product liability lawsuits against generic drug makers, impose additional cost on generic drug makers, which will ultimately be passed on to the consumer, cause some cost-sensitive generic manufacturers to leave the market completely, and increase adverse health consequences caused by consumers' lack of access to affordable medicines. Generic companies should prepare for the potential onslaught of litigation by ensuring that their company has a formal, systematic process for identifying and addressing the signs of potential litigation risk, conducting scenario planning, and creating a crisis communications roadmap to address potential implications of a loss of the preemption defense. Consider taking steps to preserve the preemption defense through regulatory action, and reevaluating current product liability insurance coverage.